The principle of arguing any litigation case is that whether you're interested party or not, there are basic principles that are followed. And that is, while it was the interested parties who argued based on international human rights law the issue of sex, they were well within their role as interested party to offer such a perspective in court. So what I will need to say is interested parties, along with my main legal team from URAP, are collectively part of a process which defended my case. And so I cannot disrespect the effort of the interested party in no way, in shape, or form by agreeing to the idea that it was not the argument we submitted. With that said, the key thing around the definition of sex, which is part of the list of description, I believe Section 53 in the Constitution, which categorizes the list of things you can't discriminate a person on, is a good point that the government raised, because we've never had any case or precedent which sets the possible interpretation around what that actually means. Outside of that, it's also the debate around sex and its extended meaning ignores the fundamental point that the case really was about adult privacy. And in that regard, our Belizeans need to recognize that unnatural crime as an issue applied to every citizen, not just gay people. In that regard, my case is about defending every individual intimacy decision around what they want to do as informed, consenting adults, not just for gay people. And in that regard, the case becomes a fundamental point in getting not only citizens to understand that, but for the judiciary to take on its role, which is to interpret whatever laws we have in a very constructive and responsible manner that is related to their job.